This lecture is a continuing expression of esteem for one of our own, a 1992 graduate of this college. Soll was an outstanding student, a thoughtful colleague, a skilled and deeply passionate lawyer, committed teacher, and much more. Named after the great Clarence Darrow, he was quick to take up the underdog's cause. He was passionate about fairness, about justice, about the idea of equality. The cases ranging from errant teenagers to the high-profile defense of Mike Tyson. That is a story worth telling, but I'm not going to tell it. He built a reputation for excellence in criminal defense. Shortly after Darrow died, Jennifer Woods, our alumna, his close friend, led an effort to establish a tribute reflecting Darrow's ideals and giving others a chance to learn and be inspired by them. Jennifer's work keeps her from being here today, but she knows who's coming, is excited, was thrilled that Steve Wright would be our speaker, and we thank her for the chance to welcome him. So today we do get to welcome who I believe would be widely considered a modern-day folk hero. He was also one of my personal heroes and a good friend from my days in Italy. Raised on a Kentucky farm by parents who were presciently and outspokenly committed to the goals of peace and civil rights, Steve graduated from the University of Kentucky, having been tagged as his first liberal activist student body president. He earned his JD also at Kentucky and began his legal career as a lawyer for the Appalachian Research and Defense Fund, and then as a Washington, D.C. public defender. His rise to prominence as a nationally regarded advocate in death penalty cases began with a phone call in 1979. Patsy Morris from the ACLU was recruiting volunteer lawyers for death row inmates. She inquired if Steve was interested in helping. Why, he asked, would anyone be interested in someone with no death penalty experience and no knowledge of Georgia law? Well, she replied, we'll take anyone we can get. That inauspicious beginning in Georgia led to a 35-year tenure at the helm of the Southern Center for Human Rights, a position that offered him a pulpit for national leadership on criminal justice issues. Frequently described as one of the nation's most tireless civil rights advocates, he has been lauded with multiple honorary degrees and national awards, including the prestigious ABA Thurgood Marshall Award in 1998. Marshall, along with other civil rights heroes, have always inspired him. In Steve's words, Dr. Martin Luther King Jr.'s message, as I took it, was that there was nothing more important than ending racism, poverty, materialism, and militarism, and nothing less important than how much money you made doing it. That suited me perfectly. He is widely credited for transforming the center into a force of justice for those facing the death penalty, for those who suffer in the nation's prisons, and those who are affected by inferior systems of indigent defense. Deciding it was time for new energy and leadership, he left the center in 2017 to continue teaching at Yale Law School and now Georgetown and Georgia State Law Schools, and addressing the challenges of what he calls keeping the fire burning inside the hearts of law students. He's argued 4 death penalty cases in front of the U.S. Supreme Court. One reporter's account noting that his repartee with Justice Scalia provoked howls of laughter in the courtroom. In fact, he's been told the case was the award for most laughter in a Supreme Court argument, though he has asked a number of times exactly what measure was used. Professor Bright was known as a powerful, charismatic speaker. We're delighted to have him here. We've been seeking to get him back for years, and he has indeed spending the whole week here, a kind of old home week with the many, many close friends he has in his faculty, including Professors Bush, Craig, Bergman, and me. Please join me in welcoming Steve.
Thank you very much, Dean Miller, for your very generous and warm introduction, which I appreciate. Mark Miller and I have been friends, as he said, for a long time, way back to the time when he was in Georgia at Emory Law School and doing so much pioneering work in criminal law in general and sentencing in particular. And so we go way back, and I just am so honored to be here. Many, many years ago, Tony Massaro, the dean then at that time, invited me to this law school, and I was so impressed with her and so impressed with this law school, and it really began a wonderful sort of relationship with the law school. And then over the years, my colleagues, two of my colleagues at the Southern Center for Human Rights, Jason Craig and Vanessa Bush, are on the faculty here now. And then my colleague from way back in the 1970s, which there was in the 1970s, believe it or not, at the public defender there, Barbara Bergman. Barbara, one of the few public defenders I know who took time out to work in the White House counsel's office when President Carter was President of the United States, and she was counsel to the President at times, and she was a public defender at times, and you're extraordinarily fortunate to have her here with the program that she teaches here. I just see, looking out there, Annette Manchet, my dear friend for many, many years, is with the Arizona Capital Representation Project, and there are many other people. I won't try to name everyone, but just say I've got a lot of friends in Arizona, and it's great to be here. I want to talk to you about what I think are two of the most critical issues that we have in criminal cases in the United States today. Dealing with the issues of race and poverty. I think we would all agree that if we want to have justice in our courts, if we want to be true to what's over the entrance to the Supreme Court building, equal justice under law, that nothing is more important than we make sure that poverty and race do not dictate or even influence the outcome of criminal cases. And a little part of what I want to talk about is the way in which courts do not reach often the merits of issues because of reasons that I would suggest at least are somewhat trivial in relationship to the constitutional issues that are given up. I'll just give one quick example, the case of a fellow named Keith Bowles, who had a habeas corpus case pending in a district court, moved the district court for time to file a notice of appeal. The court gave him, the United States District Judge gave him 17 days. And the lawyer filed on the 16th day. So far so good, huh? Unfortunately not. The statute and the rules only authorize the judge to give 14 days. And he filed on the 16th day. And what happened then? Gotcha, you can't go forward. You can't go forward with this appeal because you missed the deadline, even though you filed within the time that a United States District Judge gave you to file. The case went up to the Court of Appeals, the Sixth Circuit. They opened their opinion by saying, this is a case about deadlines. You missed the deadline. It went to the Supreme Court of the United States in a 5-4 opinion. Justice Thomas, writing for the majority, said, nope, you missed the deadline. You don't get to go forward on any issue that you have because the judge and the lawyer missed the deadline. And I'll just say a couple of things about that. One, there's another lawyer involved there. It wasn't just the judge, and it wasn't just the lawyer for Mr. Bowles. There also was a lawyer for the Attorney General's office in the state of Ohio. He could have pointed that out. In fact, I expect that lawyer probably knew that there were only 14 days. But no one expected that lawyer to come forward, or those lawyers from the Attorney General's office, and so they just waited and then said, gotcha. And I would just say that the issues, Justice Souter wrote a very passionate dissent in the case, in which he called it a judicial bait and switch, and said he would not be a part of it. But over and over we see in cases issues that do not get before courts because of some mistake a lawyer made, which often has nothing to do with the client or the issue that's before the court. And whether or not that's what we want or not, I think is something I want to talk a little bit about today. Our commitment to justice should be, as I said, preventing race and poverty from coming into play. And obviously, death cases, where the consequences are so enormous. One of the other cases in which the Sixth Circuit was really imitating was the case of a fellow named Roger Keith Coleman out of Virginia. His lawyers had missed a deadline in the state courts in Virginia, and then tried to raise those issues in the federal courts. When it got to the Supreme Court, the Fourth Circuit Court of Appeals had addressed the merits of the issues. Justice O'Connor started her opinion by saying, this is a case about federalism. And we respect what the state courts do, and the state courts of Virginia said that because his lawyer missed the deadline for filing a notice of appeal, none of those issues could be heard in the state courts, and none of those issues will be heard in the federal courts. Justice Blackmun in his dissent said, you know, federalism, comedy, states' rights, all these reasons we read about, but nothing about the integrity of the conviction. Nothing about whether the Constitution was complied with or not in the way in which this case was handled. But it's not just capital cases, it's also the municipal courts and the lower courts, which of course is where the vast majority of people who come into our court system have their dealing with the courts, in municipal courts and misdemeanor courts and the lower courts. I'll touch on that just very briefly. But in terms of talking about poverty, which I'll talk about first, the major consequence of poverty is not being able to hire a lawyer. Mark Twain said, the law is a system that protects everybody who can afford a good lawyer. Or, as the New Yorker put it, in this sort of a picture that speaks 1,000 words, you have a pretty good case. How much justice can you afford? You know, we need to worry about both of these things. We need to worry about counsel because that's fundamental to every other right a person has. Every right you have depends upon your right to a lawyer. But the other thing, of course, with regard to race, is not just a matter of how cases are decided, but overcoming a history of race discrimination, particularly in the criminal courts. From slavery to convict leasing to Jim Crow to mass incarceration, this thread that runs throughout. And I think the answers to these, which I'll come back to, is lawyers, graduates of this and other law schools, providing good representation to people who are accused of crimes. And then what can be done in the state courts, because I don't see a lot of answers to what I'm going to talk about in the United States Supreme Court or the federal courts. And of course, the vast majority of cases are in the state courts. About 5% are in the federal courts. So the action, particularly with regard to criminal cases, is in our state courts. Talking about justice. Let's talk about what justice is, and let's talk about what the reality is. The Supreme Court once said, there can be no equal justice when the kind of justice a person gets depends upon the amount of money he or she has. In fact, there's some cases in the 1950s and the 1960s in which that phrase is repeated over and over again, as the court found that there was a right to a free transcript, there was a right to a lawyer on appeal, and other sorts of things. But we all know the reality is that nothing matters more in our court system than how much money a person has. I mean, you know that right from arrest. I won't ask for a show of hands, but if any of you have ever been arrested, you know that when you're arrested and you're thrown in the lockup or the drunk tank, whatever it may be called, I've been there. I know what's going on there. There are a lot of people in there who don't look that friendly. There's a lot going on, and there's a lot of rather gross profanity being used by the people that are marching you around, and you're treated very impersonally, and you want two things. You want two things, right? You want out. Out, we want out. And you want a lawyer to get you out. And if you're a person of means, if you got money, if your family's got money, you call up and you'll get the best lawyer in town. And that lawyer, or one of the best lawyers in town, will come down, and you probably will be out in time to have dinner with the family that night. And if you're poor, depends on what court you're in, of course, and a lot of what I'm going to say, I'm generalizing. We have 50 states and a lot of courts, and different courts treating people different ways. But I know that Diego Moran, who was facing the death penalty in Texas, was arrested and asked for a lawyer and did not have a lawyer for 8 months. 8 months, can you imagine? You're facing the death penalty. And you don't have a lawyer to answer your questions like, what the hell's going to happen to me? What are we going to do to defend against these charges? What investigation can be done? What witnesses do we need to get in touch with right away? 8 months. I see so many people who are arrested and thrown in jail. We had a case in our office, a man who was arrested for the high crime of being a pedestrian under the influence. He was a man walking around town under the influence of alcohol. You could not get jail time for that offense. But they put him in jail and they set a bond of $50. They might have said $500,000 or $50 million. He couldn't pay $1. And he spent 8 days in jail because he couldn't make bond. Now, for a lot of people, what that means is you're going to lose your job because you're going to miss work. You're going to lose your home because you can't pay your rent. You're going to lose your car because you can't make the next car payment. And your whole life is going to go right off the edge. My friend Chris Phillips, a young man who barely make it, working at a liquor store as a clerk, gets arrested, 2 weeks, held for 2 weeks in jail, and then is released. Never sees a judge, never sees a lawyer. But when he got back to the liquor store, he lost his job. When he got back home, all his stuff was out on the street, even the victim. And this young man is struggling with schizophrenia, who's been right on the margins of society. Suddenly he finds himself homeless and living in the parks and in the streets of Atlanta. Ruins his life. I'm going to give a couple of examples. They're pretty gross examples, but I think they kind of make my point about how we sometimes avoid justice in order to not appeal, to not reverse the case, to just sort of go on with it. This is Robert Hulsey, African-American man who was executed by Georgia 2014. He was represented at his trial by a lawyer who was facing disbarment and indictment for stealing client funds. He was a little preoccupied with that, and over the course of the trial, he drank a quart of vodka every day. Now that may not mean anything to a lot of you, a quart of vodka, because you probably don't measure drinks by the quart. But it's 21 shots of vodka every day. Think about that. You come to school, 21 shots of vodka over the course of the day. How is that going to be? And the lawyer did, I think, a pretty miserable job by every account. He didn't put on evidence that Hulsey was intellectually limited, and that, as Judge Barquette said in her dissent in his case, that he was subject to, this is at the penalty phase when they're deciding, is this man so beyond redemption that he's going to be eliminated from the human community? And the jury didn't get the information about his intellectual functioning, or that he was subject to abuse so severe, so frequent, and so notorious that his childhood home was known in the neighborhood as the torture chamber. Now, there wasn't much problem in concluding that he was not a competent lawyer to handle a death penalty case. But the court said he was not denied the effective assistance of counsel because it didn't matter. The judges thought he would have gotten the death penalty no matter what. They applied the standard of Strickland versus Washington, a case that says you first to see if the person had deficient representation. No question about that here. No question. But secondly, you ask the question, is there a probability that it would have affected the outcome? And judges decide that. Judges who didn't sit on the jury, judges who didn't hear any of the witnesses that were called, and didn't hear the witnesses who weren't called, decide whether or not it made any difference. And in Robert Hulsey's case, they said it didn't make a difference and he was put to death. And the trick there that the Supreme Court came up with was they say now, he did not receive ineffective assistance of counsel. Because the test of ineffectiveness is not only that the lawyer has to be incompetent, but that it had to affect the outcome. But you see what a dishonest thing that is to say, and this case illustrates that, I think, fairly well. The goal here, of course, is to avoid reversal. Why try the case again if we don't need to? But on the other hand, what about the integrity of the process? What about the quality of the lawyer who's representing somebody, and whether or not you can really look at that and say that, I mean, what right is more precious than the right to counsel? And that all we have is some drunk guy. You may get off an airplane, and you may find out the pilot was drunk. Well, I guess you could say it didn't affect the outcome. You took off and you landed. But I think you'd say we don't want our airplanes flown by alcoholic pilots. And we probably want to punish the pilots for being under the influence, not punish the passengers on the plane. That's what I think is so interesting, is the legal profession takes an approach that no other profession would take. That say that, you know, I mean, this lawyer was disbarred, he was convicted, he did go to prison as a result of what happened. Not unusual in Georgia. John Young was sentenced to death in Georgia and met his lawyer on the prison yard one day. The lawyer was there on drug charges, both state and federal drug charges. So having a lawyer go to jail after the client gets convicted and sentenced to death is unfortunately not unheard of. In my view, it's totally intolerable if you want to say this is about justice. This is about justice for people who are there. In Houston, Texas, well, I want to say this real quickly, that I think the court had it right back in 1942 in a case called Glasser versus United States, in which they found that Glasser had been denied his right to counsel. And the Supreme Court said the right to counsel is too fundamental, too absolute. We don't engage in nice calculations of what difference it made. If somebody's denied their right to counsel, they get a new trial with a real lawyer. That seems reasonable to me. But now the court has said, well, actually, we'll engage in crude guesses. I mean, the Strickland standard, as I said just a moment ago, is a lawyer is not ineffective if judges say they didn't make a difference by saying there is not a reasonable probability that for counsel's deficiency that the lawyer would be there. Houston, Texas, which has killed more people than any state except Texas itself, 132. Texas is in the 500s. Only 2 other states are over 100, Virginia and Oklahoma. One of the reasons so many people are sentenced to death in Houston was the lawyers are so bad. 3 different people there, George McFarland, Calvin Burdine, and Carl Johnson, all represented by lawyers who slept during their trial. Think about that. The lawyer is sleeping during a death penalty trial. In George McFarland's case, asked the judge, how do you preside over a death penalty case when the lawyer's sleeping? He said, well, the Constitution guarantees your right to a lawyer, but it doesn't guarantee the lawyer has to be awake. Now that's a strict instructionalist, if ever there wasn't. But in what other profession can you sleep on the job like that? Joe Frank Tanner was a lawyer who slept in 2 of those trials. Judges kept appointing him. That's the other thing that I find remarkable. Some people have no review of their cases whatsoever, and I'm talking about death penalty cases, because their lawyers missed the statute of limitations for getting into federal court and having federal life tenure judges review the cases. I will tell you, my 40-some-odd years of practicing law, life tenure judges are often see cases much differently than elected state court judges, who have to think about whether they're going to be reelected again, depending upon how they rule in a case. And my thought has always been about that. We ought to be punishing, again, the lawyers, not the clients. I mean, Jerome Godnich, a lawyer in Houston, missed the statute of limitations 3 different cases. His clients get killed because he missed the statute of limitations, and he still gets assigned cases by the judges in Houston, Texas. How can you justify that? But that's what's happening in our courts today. And as I said earlier, if you go to traffic court, if you go to the misdemeanor courts, the municipal courts, and what you see in there, the Supreme Court in 1972 recognized, Argersinger versus Hamlin, that what was going on in misdemeanor cases was what they call assembly line justice. That people were being processed through this bunch of people who are all pleaded guilty together and all being sentenced together. They're doing it by groups of people. And the Supreme Court said this is intolerable. So there's a right to a lawyer in any case in which you can lose your freedom. But if you go back to those courts today, you will find that the description of them In the 1972 Argersinger case, the description is exactly what you see in those courts today. You see people processed through those courts. And you see cases decided in minutes. You see cases where people meet with a lawyer and talk to the lawyer and then go in and plead guilty and get sentenced. And that's the only time they spend with a lawyer. And that's the only time they spend before a judge. Called meet them and plead them. And I've seen it over and over again. And I think it's one of the biggest charades in our legal system. Because everybody, when all these people are pleading, everybody, the judge, prosecutor, defense lawyer, all the family members sitting out there in the audience public, they know this is a complete charade. They know there wasn't any legal representation provided to these people. They only met with a lawyer for 15 minutes. There was no investigation. There was no review of any documents. There was no determination of whether there were legal issues that should be litigated in the cases. It's a complete farce. But it's moving people through these courts, and this is happening all over the United States of America that this is happening. And I think that's one of the times when our legal system really does not pass muster just from the people who come before the courts. In the few cases that do go to trial, and of course most cases are not resolved with trials. Most criminal cases are resolved with guilty pleas, as you probably have learned. I want to talk just briefly about the ones that do go to trial, because very often the success of the prosecution in convicting people, it depends upon the success of excluding people of color from participating in the juries. As you know, each side in a case has so many peremptory strikes that they can use for any reason to remove people from serving on the jury. And another charade that we see in courts all the time is lawyers striking all the people of color from the jury, whether it's Hispanic people, whether it's African American people, whether it's Native people, whoever it may be. And then there's an objection, and then the person stands up, the opponent stands up and objects. That strike is based on race. And the judge said, give me the reasons for your strikes. This is in the case of Batson versus Kentucky, that if there's a disproportionate number, people strike. Got to give reasons. So the prosecutor gives the reasons, and everybody knows good and well that those reasons are complete lies. The reason those people were struck was race. That's why they were struck. I mean, we all know that. But we're going to pretend that it was because of the reasons that are given. As Judge Bennett said, who's on the district court in Iowa, what this does is it requires the judge to decide is the person, and these apply to everybody, but for every party can be challenged on use of strikes. But to keep it simple here, I'm going to talk about prosecution and defense because that's what I see all the time. That you have to convince the judge that the prosecutor is a racist, intentionally struck on the basis of race, and secondly, lied about it by giving a pretextual reason instead of the actual reason. You really think that's going to happen? I mean, so often the courts I practice in, the judges were the prosecutors. They used to strike all the blacks themselves. So they know the game. And the person who's now the prosecutor was their chief assistant. But even if that's not the case, if you have judges and lawyers who work together all the time, that's going to be a hard call to make. But at any rate, I just want to make a couple of points about after Batson was decided. What so many, certainly not all, I'm sure, but all that I know about, prosecutors got busy in doing was not complying with Batson and ending race discrimination, but finding ways to get around race discrimination. There was a lawyer in Philadelphia, Jack McMahon, who was the chief prosecutor in the district attorney's office in Philadelphia, and he has a training tape in which he's explaining how to get black people off the jury and get away with it. Not pick the juries the way you're supposed to, and not let race come into play, although the question is, can you really do that? I mean, in my classes, I always have an experiment where we come down to the end, and depending upon the strike, you're either going to have a young black woman or an older white man who's an accountant, a woman who's a teacher. You strike, which one are you going to take? To the prosecution, which one are you going to take? Can you really exclude race in making that decision between those two people? If you can, I'd like to know how you do it. But he tells them, now when you're picking a jury, you ask those black people questions and you write down on that little sheet you have. You write down some reasons, because you got to give some reasons. So you got to be making up reasons right from the start. And he also talks about when you question them. Well, you say this woman had a child the same age, so that's why I struck her. It wasn't race, she's unemployed. I struck her because she's unemployed. So you want to ask more questions of those people, meaning in Philadelphia, black people, to give you what you need to have an articulable reason for striking people on the basis of race. This only came to light because McMahon, 10 years later, ran against the incumbent district attorney, and she released the tape in order to hurt him politically, and at the same time kind of spill the beans on everything that was going on in the district attorney's office. One of the Illinois courts, the Illinois Intermediate Court, said that surely every new prosecutor is given a manual of handy race-neutral reasons, handy-dandy, time-tested race-neutral reasons. They were being sarcastic. But the truth of the matter is that we know that prosecutors in a number of places, including Texas and North Carolina, trained on how to give reasons to justify striking black people in those states. Reasons like age, too young or too old, attitude of defiance, lack of eye contact, body language, all kinds of body language, long hair, and a goatee. Boredom, that's one that I found really interesting. I picked a lot of juries. You ever been on the jury? Is it exciting? I don't think so. You got to wait around an awful lot of time. It's pretty boring. Really, most people are going to be bored to the jury selection process. Facial expression, sunglasses, t-shirts, chewing gum, all these reasons that are on this sheet of paper called articulating juror negatives. So you don't give the real reason that you struck the person. Of course, that reason is race. You look down at your sheet of paper there and you read off, well, that juror was wearing a t-shirt instead, or that juror was chewing gum. So I didn't want that person on the jury. I didn't like their body language or all those reasons. There's a podcast that I recommend highly to you. It's called In the Dark, Season 2, about the case of Curtis Flowers. Curtis Flowers tried 6 times for the death penalty in Mississippi. 6 times. Reverse, mistrials, all that. Last trial, death penalty. Just a week ago, the Supreme Court of the United States granted certiorari in the case. It's going to be argued in the spring, and it will be decided in the spring. Keep an eye on Curtis Flowers. In one of the trials, the prosecutor used 15 out of 15 jury strikes against African Americans. Even the Mississippi Supreme Court said that's too much, and they reversed the case. In the community, Montgomery County, where that case comes out of, 45% African American. Yet the juries almost all have had either no African Americans or 1 or 2 African Americans because the prosecution strikes the African Americans. And in one where there was 1 African American and 11 whites, the jury hangs 11 to 1. All the white people, conviction. The 1 African American man, a veteran of the Vietnam War, football referee, retired school teacher, Mr. Nibbs. He's the one holdout, and they lock him up and throw him in jail and accuse him of lying during the jury selection process because he was a holdout after hearing all the evidence. There was another trial in which there were more black people, and 2 trials were mistrials. That was one, and the other one had more black people, and they didn't lock all them up. But if you listen to that, you'll learn a lot about it. And then there's my case that I argued in the Supreme Court, which I'll just touch on very, very quickly. It's kind of like Jack McMahon's training tape. It gives you a little behind-the-scenes look. This was the list of, whoops, back up one. This was the list of all the potential jurors, and it went on for a number of pages. It's a printout of all the people who are summoned for jury duty. And you'll see that some of them are highlighted in green. Those are the black people. And just in case you're colorblind, there's a little B beside their name. And then here are the jury questionnaires. This is where the prosecutor identified the jurors. B1, B2, B3, and so forth. And then one of the investigators in the prosecutor's office was asked to prepare a memorandum comparing the black jurors with each other in case we have to take a black person. It said there, if it comes down to having to pick a black person, Ms. Garrett might be okay. But the truth of the matter is, Ms. Garrett was never going to be on that jury. Because here were the lists, definite no's, 3 different lists that have all the African-American potential jurors. These are the jurors who are going to be struck the next day. This list was prepared on Sunday, and on Monday morning when they got to court, they struck these people. This was something else in the prosecutor's file about the Church of Christ. They struck one African-American man and said he's a member of the Church of Christ, and people in the Church of Christ are so adamantly opposed to the death penalty, we can't let them on the jury. Well, here in the prosecutor's own handwriting, this thing has a mind of its own, in the prosecutor's own handwriting leaves it up to each individual person in the congregation. And then down lower, no black jury. And then the prosecutor's closing argument imposed the death sentence on Timothy Foster in order to deter people in the projects. 90%, including the Foster family, 90% of the people in the projects African American. That was the case. Now, if we hadn't discovered that file, Tim Foster would have been executed by the state of Georgia. It was only serendipitously that we were able to get that because we made an Open Records Act request and the prosecutor had forgotten to shred the notes or burn them or whatever it meant to do with them. But they certainly didn't mean for us to have them. The Supreme Court held that was intentional race discrimination, but I make this point about it. This is what the court loves to do. Find discrimination case not going to affect anybody else because you're not going to find this kind of smoking gun evidence of race discrimination. This was B1, Eddie Hood, said when he came home he told his wife, more than likely there are not going to be too many of us on the jury. See, everybody knows what's going on here. Everybody knows. Miss Garrett said they just kept asking her over and over again why she had 2 jobs. She's a single parent. She's trying to take care of her kids. That's why she had 2 jobs. And then when I got defensive, they said I was indignant. They treated me like I was a criminal. They had me in tears when I went out there. I'm a very sensitive person, and I didn't expect to be treated that way. It was really humiliating. One of the things we have to think about in these cases is what the impact on the community is. I heard a case in the Supreme Court called Snyder versus Louisiana. Part of our evidence was that if you lived in Jefferson Parish, the white flight parish around New Orleans, you didn't serve on the jury because the prosecutor struck all the people of color during jury selection in any kind of criminal case that was there. And we said to the court, you know, the black people in Jefferson Parish, they know they're totally disenfranchised. They do not participate in the legal system. But you know what? The white people know it too. And this doesn't have much credibility and much legitimacy in that community when these people who are part of the community are systemically excluded. Well, what do we do about it? Let me say a couple of things and go to Washington, the state of Washington, because 2 very interesting things happened there this year with the Supreme Court of Washington. It had pointed out, as have other state courts, that discrimination in jury selection is rampant. And the city Supreme Court said that in Flowers. And other courts have said that. And they kept warning, if you keep striking on the basis of race, we're going to do something about it. And then, of course, they never would. And so it's sort of like people warning their children not to do something. I'm going to count to 10. I'm going to count to 10 again. For the 3rd time, we're going to count to 10. But you never do anything. The Washington Supreme Court in April put out a rule that said, now the standard is not whether there's intentional race discrimination, but whether an objective observer, seeing and knowing all the facts, would think that race or ethnicity was a factor in exercise the strikes. And it specifically says the objective observer is a person who's aware of implicit institutional and unconscious bias. It's a person who realized that discrimination has resulted in the unfair exclusion of jurors in Washington. The rule provides specifically that the court does not have to find what Judge Bennett talked about. It does not have to find intentional race discrimination. And it goes on. This is a remarkable thing, in my opinion. It says presumptively invalid is any excuse like prior contact with law enforcement, expressing distrust of law enforcement, having a close relationship with people who have been arrested or imprisoned, living in a high-crime neighborhood. These are all the so-called race-neutral reasons on those lists that they passed out in Texas and North Carolina. Having a child outside marriage. And with regard to the demeanor reasons, like, you know, no eye contact and that, says allegations that a prospective juror was sleeping, inattentive, failed to make eye contact, body language, and so forth. If anybody wants to rely on that, they've got to give notice to the other side and the judge, and unless the judge makes a finding, because so often they say, well, the person didn't make eye contact. Who knows whether they might make eye contact or not? But not in Washington anymore. So that's pretty remarkable. A lot of these states, you know, raise their hand, we can't do anything about race discrimination. You know, they give these race-neutral reasons. We've got to accept them. I mean, you know, a lot of courts, Louisiana and North Carolina, have never, ever reversed a case for race discrimination. I'll tell you this, it's not a very good case to be made that there's no race discrimination going on in those states. The second thing that they did just a short time ago was a case called State versus Gregory, in which the Washington Supreme Court held that the death penalty was unconstitutional under the Washington Constitution, under the state constitution in Washington. Main reason for that was because of race discrimination, because of a study that showed that race was the key factor in who got the death penalty and who didn't. But they pointed out another thing that's kind of relevant here in Arizona, that of the 39 counties in Washington, prosecutors were only seeking the death penalty in 3 counties. That it basically was not even considered in the other counties because of expense or whatever. If you look here in Arizona, of the 15 counties, only 5 have really been active in pursuing the death penalty. I don't know what necessarily it's going to happen in any particular state, but I think people ought to be looking for ways in which state constitutions can be a way to to deal with race and to deal with this sort of arbitrariness that only 3 or a handful of counties in the state. Of course, this is what we know nationally. 2% of all the counties in the United States account for well over half the people on death row and well over half the executions. And then with regard to counsel, we have to have in every place around this country public defender programs staffed by good, conscientious, zealous advocates who are going to provide client-oriented advocacy to represent people, and lawyers who are going to go out and take on these cases. I mean, these are the big challenges, and I just want to say that it's extremely important that anybody who graduates from law school, I don't care what kind of lawyer you are, whether you're a prosecutor, whether you're an attorney general, whether you're a big firm lawyer, whether you're a big fat cat, wealthy lawyer, whether you're a poverty lawyer, everybody's got to be involved in making access to justice available for everybody. I mean, you're going to be, when you graduate from here and you're lawyers, you're going to be trustees of the system of justice. It's in your hands. And you can either use it as a get-rich-quick scheme, which it is, no doubt about it. See about rich lawyers that get rich, they got rich quick. But that's not what it's supposed to be. It's supposed to be a system that resolves disputes in a civilized and reasonable way, and it can't do that if people have no access to the system. And where people don't have access to the system, if we're not going to provide lawyers, or if we're going to do as bad a job as we've done in misdemeanor courts, where Chief Justice Berger said, well, I don't know what we're going to do about providing lawyers in all these courts, but I know the legal profession is up to the task. He was wrong. The legal profession is not up to the task. The courts are as bad today as they were in 1972. But I'm saying the legal profession needs to take this on. When the Supreme Court held this Strickland versus Washington, that basically any kind of lawyer will do, they said we're going to leave it up to the bar to make sure the lawyers are competent. But the bar hadn't responded to that. But you have to do that no matter what you're doing. We have to all take an interest in it, because as Robert Kennedy said when he was the Attorney General, the poor person accused of a crime has no lobby. There's no lobby for people who are poor, who are desperate for legal representation, who may be innocent but don't have lawyers, who may be not guilty of what they're accused of but something else, and people who need lawyers for sentencing and all other sort of things. And I would just say this in closing: where you stand is what you see. And you need to stand, at least at times, with the marginalized and the outcast and the powerless and the despised and the condemned. In short, the people who suffer. You need to see life from their perspective. And it's the responsibility of all of us to try to do that. Great poem, great poet Langston Hughes wrote, "There's a dream about the land with its back against the wall. There's some of those who would claim the dream for theirs alone, a sin for which we surely hope they will atone. Because unless shared in common, like the sunlight in the air, this dream will die for lack of substance anywhere. The dream knows no frontier or tongue, the dream no class or race. This dream cannot be kept in any one locked place." This dream today in battle with its back against the wall, to save the dream for one, it must be saved for all. Thank you very much. Dean, how much time do we have?
Definitely time for some questions. So.
Okay, I wasn't sure. Yes, ma'am.
I wonder if you could give us some advice for those of us who want to go into public service and work in defense, how to be empathetic without becoming sort of like overwhelmed with what's going on. Like, how do you draw the line? How do you keep the barrier between like your personal life and your empathetic nature and what's going on daily in the defender's office?
Gosh, that's the hardest question anybody could possibly ask, I think, because I think it depends so much on the person. It depends on who you are. I would just say this. I think people who really talk a lot about detached professionals and all that, I'm not on that boat. I understand some people sail off on that boat, and I respect them. But I've always found that getting to know my clients, to love them unconditionally, to support them in every way I can, to just, that's a good part of my life. I think it's improved my advocacy and my ability to help them, but it's also been a satisfying life for me. It might not be for somebody else. So I think people just have to kind of work that out. There are people who don't want to do death penalty cases. I have lawyers all the time who say, I would not want to represent anybody in a death case and have somebody's life in my hands. But other people do that and do it very well. You have outstanding people here in Arizona who do that, as all over the country. So I think it's calibrating, you know, how far you want to go and where you can go and how deeply you're involved. I think a public defender practice, I was talking to some students yesterday, and I said, you know, it goes with the territory. If you're a public defender, that you're going to have a very heavy caseload. That just goes with the territory. Unfortunately, as Robert Kennedy said, there's nobody making sure that public defender offices have the resources that they need. It's tragic in a country this wealthy. I mean, some third world country, we could justify some of what goes on in the courts in this country, but not in the United States of America, not with all the money that we have. But at any rate, that's a different point. But so I think that's one thing too. People have to calibrate. You know, are you going to go someplace where you have to? Can I deal with it? Can I deal with it? I certainly think people still have to have a life, and they have to take vacations and have families and all that, and people do. But that's a real hard question to just answer generally. I appreciate it, but it's hard to answer generally, I think. Yeah? Yes?
You started off by saying that we're not going to get relief on these issues in the Supreme Court. And Justice Ginsburg, and we have a majority conservative court. I wonder if Justice Ginsburg broke her ribs. Many of us are praying for her health and longevity. Should she not make it and be replaced by a conservative, can things get worse? And do you think there would be an impact in these issues?
One thing I've learned in over 40 years of practicing law, things can always get worse. I think they're pretty bad, but they can get worse. And you know, things have happened over my lifetime that I must say, quite frankly, I never thought I would see, but we do. So we'll just have to see what happens with the court, but there's already a very solid majority that, you know, the last case I argued was a case about the right to a mentally ill, brain damaged man in a death penalty case, whether he had a right to an expert. And the court held 5-4 that he did. Justice Kennedy, of course, keep up. If that went before the court today, come out the other way. Didn't have anything to do with me, my advocacy, anything else. The bottom line is, the majority today would not see that. And that's pretty fundamental. I mean, if you, in today's world, if you don't have access to experts in criminal cases, you really are, you know, you just can't, you know, I hate to say this, but the truth of the matter is, you give somebody a bad lawyer, the case is rigged. They're going to lose. You give somebody a bad lawyer, it's just like a wrestling match. They're going to lose. Everybody knows that when the lawyer's appointed. Now, there are gradations of that, of course. But you deny people of experts, where experts are the issue, well, of course, you're going to lose if you do that. If we really care about fairness, justice, we're going to make experts available, at least where it's an issue in the case, as it was in that case. Is the man going to die? Do you want to know about his brain damage? Do you want to know how it affects him? You know, don't you want to know that? As I said, we won by a single vote, but we lose today. Yes, ma'am.
So actually, that was my question. You talked about the cost associated with hiring a lawyer, and I was wondering what you talked about in terms of the cost of generating and evaluating evidence, and have you seen that change over time? Not just from the defense perspective, but from the state perspective. So for example, I don't know if this is true, but there was a documentary that mentioned that Kentucky limits the amount of evidence that individual police departments can send to the state to be evaluated. So have you seen that change over time?
That it limits the amount that the police can submit to the,
Yep.
never heard of that.
I don't know.
But I will say this, I mean, one area of improvement that I have seen has been with regard to right to counsel. I mean, Virginia, as I mentioned, the two states that have had over 100 executions besides Texas, Virginia and Oklahoma. But Virginia, a number of years ago, created 4 capital defender offices, so that instead of being represented by some walking violation of the 6th Amendment, people in Virginia were represented by lawyers who actually knew what they were doing. What a radical thing. There hasn't been a death sentence in Virginia since 2011. Georgia set up the same thing in 2005. There hasn't been a death sentence in Georgia since 2014. Now, there are a lot of other factors, but I'll tell you, one of the key factors is that people are being competently represented. At least the lawyers know what they're doing. And also, in a lot of states now, the state public defender has a budget, so that the budget is not being decided by judges, it's being decided by the public defender. But even there, you've got, it only goes so far, so you've got a lot of difficult issues there. My observation has been generally there's no limit on the amount of generosity that's provided for crime laboratories and police departments and all of that. There's a huge amount of spending that goes into that. And you know, it just results in a very one-sided system as a result.
Time for one more question.
Yes, ma'am.
For General Rule 37.
You speak real loud, I can't hear you.
Sorry, for General Rule 37, Washington's objective standard, are you at all worried that it will just push discrimination more underground to where it's undetectable?
Well, let's hope that it won't be undetectable, but what we always are struggling with, I think, when we're talking about standards and burdens and all that, is can we bring this out in the open? What we have found with the Batson rule, it's been total failure, in my opinion, because judges are not going to make findings that prosecutors or defense lawyers or any other lawyers in the system are intentionally discriminating and lying about it. I think everybody knows that's what's happening, but nobody really wants to pony up to that and admit it. And so you see those cases occasionally on appeal where they're side-by-side comparisons where you see, and this happened in Foster's case, they said they struck Ms. Garrett because she was close in age to Foster. She was 38 and he was 18. And they accepted a white man who was 21. So that reason just didn't wash. I guess they just hadn't thought about it when they offered it as their reason. So you see those kinds of things from time to time. But it's a harsh finding that you have to make Maybe in a appellate court can find it more easily because there's some distance there, but it's awfully hard for trial courts. But I think by taking those two elements out of it, Washington now has done something that lets everybody know, all lawyers in the whole state of Washington, that if you're trying a case in the state courts of Washington, they're serious about race discrimination.
I just want to say quickly that if anybody, I've been a criminal defense lawyer and a capital defense lawyer here for 37 years. If anybody's thinking that the kinds of things that Steve's talking about in Georgia or Mississippi or Louisiana don't happen in Arizona, don't believe it. We do have one of the leading death sentencing states in the country, and the same kinds of discriminations happen here. So we need all of you to go out and fix that.
And I think I had the pleasure yesterday of being down at the public defender office. I think you have a good public defender here in Tucson, and lawyers equipped to handle capital cases, capital unit. But you don't have that in a lot of other places, here in Arizona, as well as in other places. And the way we're going to make this work is for people to go out here and say, I'm going to be a criminal defense lawyer, I'm going to learn how to do it, I'm going to be conscientious, I'm going to be zealous, I'm going to be client-oriented, and we'll build it from the bottom up. Build it from the bottom up.
So we'll continue to do our part to do that here, but Steve, looking at the list of schools you're now teaching at, you need a Western school too, so let's see if we can get